and good afternoon, and a very warm welcome to the second installment in the Global Litigation Lessons series hosted by Cornerstone Climate and Mishcon. As some of you will know, we had our last session, or first session really, in March, focused on Australia, and today we turn the spotlight on India, which I'm very, very excited about. As all of you will hopefully know, India is one of the fastest growing economies in the world and home to the most number of people in the world. Its unique geography, including extensive coastlines and mountain ranges, means that it is particularly susceptible to the impacts of climate change, including heat waves, floods, and water scarcity. Against that sort of factual background, India's 2030 NDC commitments under Paris Agreement include a number of things, but particularly reduction in emissions intensity of its GDP by 45% from 2005 levels, and also a target of 50% of its energy requirements from non-fossil fuel-based energy resources by 2030. Now, interestingly, the original targets were actually surpassed. So in terms of renewable energy, the original target was 40%. This was surpassed in 2023, and India therefore updated its NDC targets to 50%. So clearly good progress is being made in some areas, particularly renewable and low carbon energy. But there is an interesting and ongoing debate on how this ambition may conflict with other ecological concerns. And that is something we will be looking at today. Now, India has not officially submitted its 2035 NDC, and we wait to see how it builds on the 2030 targets, but it has committed in the meantime to achieving net zero emissions by 2070, with a plan to explore carbon dioxide removal technologies to facilitate this transition. So in short, there is a lot of work to do. And the question then is, how do we actually get there, and what role can the courts play in ensuring that the government meets or even exceeds its climate targets? And having posed this question, this is where I turn to the combined expertise of the incredible speakers I'm joined by today. I'm so thrilled to have three leading practitioners and academics with me. And by way of introduction, I have Vanitha Bhargava, is a partner at Khetan and Company. She is an advocate on record in the Supreme Court. She has more than 25 years of experience in a range of environmental matters, spanning mining laws, forest laws, waste management, and a lot of experience in domestic and international arbitration. She also regularly appears before the National Green Tribunal, which she will tell us a bit more about today. I then have Shabani Ghosh, who is also an advocate on record in the Supreme Court of India, and she's a visiting fellow at the Sustainable Futures Collaborative. Shabani has appeared in environmental cases before the Supreme Court of India, the High Court of Delhi, and the National Green Tribunal as well. She researches and writes on issues relating to environmental law, regulation, and governance, and so will be drawing on both her research and practice in this area. And then last but not least, we have Parul Kumar, who is a doctoral candidate at QU Leuven, Belgium, where her doctoral research focuses on the role of constitutional law and, by extension, human rights law in the field of climate litigation. Her comparative analysis focuses on jurisprudence from India and Europe, with her research being published in leading law journals. Her professional experience spans working as a dispute resolution lawyer, as well as policy specialist in climate policy-focused think tanks. So as you can tell from that very kind of short biographical description of each of them, they're extremely well qualified to speak to the role of climate legislation and the courts in India. So without further ado, I will turn first to Vanitha, who will provide a legislative and regulatory overview in this area and touch on the judiciary's role in tackling environmental and climate concerns.
Thank you, Richie, for the kind introduction. So good afternoon, everyone. And I will begin with giving a brief outline of the history of environment legislation in India, the legal landscape, the trends and developments, and challenges faced in compliances of environmental laws. So if William, if we could start with slide 6, please. You can straight away go to slide 6. Thank you. So now, before the 1970s, there were very few legislations regulating environment in India. The Shore Nuisance Bombay and Colaba Act of 1853 was one of the earliest legislations regulating water pollution. Thereafter, there were various acts like Indian Penal Code 1860, Indian Easements Act 1882. They also provided for provisions for protection of water bodies. The earliest laws that aimed at controlling air pollution were the Bengal Smoke Nuisance Act of 1905 and the Bombay Smoke Nuisance Act of 1912. Thereafter, the Indian Forest Act 1878, which was followed by Indian Forest Act 1927, and which is still in force, notified reserve forests where no activity can take place and seeks to prevent deforestation. But however, in India, the concern for environment grew in the 60s and 70s after the United Nations Conference on the Human Environment held in Stockholm in June 1972. India became a signatory to various other multilateral environment regimes and framed various acts like Wildlife Protection Act 1972 and Water Pollution Act 1974. More importantly, the Constitution of India was amended in 1976 by way of 42nd Amendment, which introduced Part 4A and included Article 51A in the chapter Fundamental Duties. It cast a duty on every citizen to protect the environment. But for Article 48A also cast a duty on the state to endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. And Supreme Court in a number of cases has interpreted Article 48A, which falls under directive principles and not fundamental duties, as imposing an obligation on the state. The 42nd Amendment also moved the category of forests from the state list to the concurrent list, which meant that the central government as well as the state governments could administer forests. An Indian constitution is among the few in the world that contains specific provisions on environment protection. Environment protection then gained momentum in the 1980s, and unique to India is the concept of public interest litigation, that is activism, which really drove the environment protection momentum. Any public-spirited person who has no locus could file a case directly before the High Court or the Supreme Court, raising issues where public interest is involved. And Supreme Court has passed landmark judgments in such cases, recognizing right to clean environment as a fundamental right, recognized polluters pay principle, which requires that polluters shall pay the cost for remedying the environment, etc. And many administrative and legislative changes relating to waste management and measures to tackle air and water pollution were brought about due to judicial activism. And it may be noted that it's only in July 22, the United States voted in favor of a United Nations General Assembly resolution that recognized the right to a clean, healthy, and sustainable environment as a human right. William, if we can move to the next slide, slide 7. Now, even though there were these legislations up to the 1970s, but the Bhopal gas tragedy involving a gas leak gave a major push to the enactment of the Environment Protection Act 1984. This is the umbrella act for the protection and improvement of environment. It defines the term environment very broadly to include water, air, noise, etc. And under the act, wide powers have been delegated to the Ministry of Environment to issue notifications for the protection of environment, including laying down standards for emission or discharge of environmental pollutants, restriction of areas in which any industries can be set up, laying down procedures and safeguards for the prevention of accidents which cause environmental pollution, and remedial measures, etc. If we can move to the next slide, please. Some of the rules that have been framed under the Act relating to waste management, air pollution and water pollution, conservation of groundwater, etc. There are hazardous waste management rules, chemical accidents emergency planning rules, biomedical waste management rules, noise pollution rules, ozone depleting substances rules, more specifically to climate mitigation, climate change mitigation, batteries waste management rules, e-waste waste management rules, etc. Various guidelines have also been laid down to control groundwater extraction, to impose compensation. So the delegated legislation is pretty wide, and there are standard of procedures which have been laid down by authorities, etc. So even though there is an umbrella act, but because of the delegated legislation, the compliances are scattered far and wide in various guidelines and rules. We can move to the next slide. So and various other important legislations other than the Environment Protection Act. There's the Forest Conservation Act of 1980, which provides taking forest clearance for carrying on any non-forest activity. And this imposes various conditions, including compensatory forestation. So a company, any industry will have to do afforestation of twice the area which it has deforested for setting up any industry. The Indian Forest Act, as I mentioned, declares reserved forest, protected forest, and village forests. And in reserve forests, no activities can be carried on. The Wildlife Protection Act declares areas as national parks. There's Biodiversity Act, which provides for payment of benefit sharing fees for access to biological resources. The Water Prevention and Control of Pollution Act and Air Prevention and Control of Pollution Act provides that industries will obtain consent before commencing operations, and it lays down conditions to prevent water and air pollution. The Mines and Minerals Development and Regulation Act deals with mining of minerals in an environmentally sustainable manner and also has provisions for protection of environment. Specific to climate change prevention and mitigation, the Air Prevention of Pollution Act provides that state boards shall lay down standards for emission of air pollutants into the atmosphere from industrial plants and automobiles, or for the discharge of any air pollution from any other source, not being a ship or aircraft. But these till now pertain only to the emissions which are emitted from the operations of the industry, not any indirect emissions. And state government may declare any area as an air pollution area. It may prohibit the use of any fuel that may cause or is likely to cause pollution. State government may prohibit the burning of any material which causes pollution. And as I mentioned, no industry can set up or carry on its operations without the consent from the various respective state boards. And upon non-compliance, consent can be revoked. Now, in spite of these wide range of legislations, the issue that was being faced was non-enforcement or lack of very strong enforcement by the authorities. And the enactment, if we can move to the next slide, please, William. So the enactment of National Green Tribunal Act in 2010, again due to directives given by the judiciary to set up such a tribunal, it gave a further boost to the enforcement of environment laws. And the specialized tribunal issued, it had more power, it had more enforcement. The predecessor did not have any, very strict powers of enforcement. So this specialized tribunal issued strict directions to regulatory authorities for enforcement and sometimes imposed heavy compensation not only on the polluters, but on the enforcement agencies. Its judgments also spearheaded changes in legislation like making zero liquid discharge compulsory, directing authorities to frame compensation guidelines, because the Environment Protection Act only provided for a very minuscule amount of compensation, which was not acting as a deterrent, and direct government to enforce waste management, etc. And many judgments were focused on issuing directions on mitigating effects of climate change, such as introducing embargo of use of vehicles more than 15 years old, proper storage and disposal of fly ash, enforcement of emission norms, directing industries to install air pollution control devices, online real-time monitoring mechanism, etc. The specialized tribunal also lessened the burden of environmental cases, which were pending because of various public interest litigations in the Supreme Court and the High Court. So having been representing the other side of environmental law, basically the companies who pollute, I would say that it did bring about a change in the mindset of industries as well by making them take preventive measures and more compliant. There has been a change of attitude, and we have seen since the NGT was established. And then there are suo motu powers which have been given to NGT and has been upheld by the Supreme Court, which acts as a secondary enforcement and monitoring mechanism apart from the regulators. If we can move to the next slide, William. Then there are these various regulatory authorities, the nodal agency being the Ministry of Environment and Forest, which frames legislation, oversees other regulatory bodies, and also frames policies. It works with other ministries like Ministry of Power, Ministry of Renewable Energy, etc. Central Pollution Control Board, CPCB for short, provides technical services to the Ministry of Environment. Its primary purpose is to give technical assistance to the central government, lay down standards, assess water quality and ambient air quality. They also from time to time issue guidelines for adaptation of new technology by the companies. For example, use of alternative fuel like biomass, etc., waste to fuel technology, establishment of desulfurization plants and thermal power plants, which sadly has been extended from time to time. Then further, various authorities have been constituted to monitor and enforce regulations pertaining to air, water, and land. Example, the National Coastal Management Authority, National Board for Wildlife, Central Groundwater Authority, Wetlands Authority, Commission for Air Quality Management in National Capital Region and adjoining areas. If we can move to the next slide, please. Now, before setting up any industry, industries also have to obtain prior environment clearance under EIA notification 2006 in order to establish any project. An environment impact assessment is carried out by expert appraisal committees constituted by the central and state levels, depending on the size of the project. Various amendments have been brought about in the last 18 years to this notification. Industries to be set up in certain forest areas have to obtain forest clearances. Notifications have been issued regarding areas around national parks called eco-sensitive zones where where activities are not permissible. Companies also have to obtain permission from Wildlife Conservation Authority, Coastal Zone authorities. They have to obtain consent under the Water and Air Act and hazardous waste management rules. And courts have recently come down heavily on companies operating without prior consent and ministries and for carrying out operations without proper permissions. But ministry has, however, issued notifications for ex post facto clearance subject to fulfillment of certain conditions. There was a very small window, and currently Supreme Court is also adjudicating whether that small window could have been open to continue granting ex post facto clearances to companies. Then if we can move to the next slide, please. So my co-panelists would be dealing in detail with the recent reforms in the judicial precedents. Government has also initiated various policies with the intention to achieve the nationally determined contributions under the Paris Agreement. But I'll very briefly just give a few developments that have been driven by the judiciary. So the Supreme Court has held that every protected forest should have an eco-sensitive zone of 1 kilometer where no developmental work shall be permitted. And this is in states where minimum distance has not been provided. Recently, since 2021, many waste management rules of plastic, batteries, e-waste, etc. have been amended to boost a circular economy and impose extended producer responsibility obligations, and has sought to create a market-based mechanism. The Ministry of Power introduced green hydrogen policy. The Ministry of Power has also framed rules for purchase and consumption of green energy, including energy from waste to energy plants, which provide for renewable purchase obligations. There's been as a deterrent, the Prevention of Money Laundering Act was amended. And in proceeds of crime, it includes property or profits which may directly or indirectly be derived or obtained as a result of any criminal activity, including discharging effluents or emissions. And in 2020, all vehicles sold in India were mandated to comply with Bharat Stage 6 emission standards. They have provide legal limits on the amount of air pollutants like carbon monoxide and particulate matter. There's been a total ban on single-use plastic since 1st July 2022. The Director General of Foreign Trade has issued notification where import of certain hydrofluorocarbons can be permitted only with the recommendation of the ozone cell. And this is to meet the phasing out target of production and consumption of HFCs under Kigali Amendment of Montreal Protocol. The Bureau of Indian Standards has also come out with various quality control orders laying down standards for certain environmentally harmful substances. Energy Conservation Act has also prohibited certain manufacture and import of equipment or appliance which do not conform to energy consumption standards. The carbon credit scheme has been introduced, which has developed the Indian carbon market, objective being to decarbonize the Indian economy by pricing greenhouse gas emissions through trading of carbon credit certificates. There has been decriminalization of environment laws. It is still to be seen whether they have removed the deterrent, and more than decriminalization, they are imposing heavy penalty on companies which are non-compliant. They are regulating greenwashing. Advertising Council of India has published draft guidelines. to curb the practice. If we can move to the next slide, William. So judiciary has leaned towards liberal construction of this beneficial legislation and generally have resorted to judicial activism, but they have also tried to balance sustainable development, India being a developing country, and adopted doctrine of proportionality in deciding punishment for violation of environment laws. For example, the right to clean and healthy environment has been recognized as fundamental right. The courts have encouraged solar projects and renewable energy projects, and in some cases, courts have balanced environmental impact of renewable projects and upheld the same, being less harmful than fossil fuels. For example, there are a lot of dilution of the clearances which are required for other industries for renewable projects. Supreme Court has also introduced doctrine of absolute liability on the user of hazardous material. As they have passed reduction of they have passed orders for vehicular pollution from vehicles. They have banned use of pet coke in the NCR region. Directions have been issued by Commission for Air Quality Management to phase out use of phase out use of fossil fuel and use biofuel. And if we can move to the next slide, please. There are many challenges. I mean, even though India does have a robust legislation and the powers of the delegated authority also are quite robust, unlike the recent US Supreme Court judgment, which said that the regulators cannot really lay down emission standards. But there are various difficulties faced in compliance of environment laws. One is the legislation complexity. So even though giving delegated powers, it quickens the job of the delegators to come out with guidelines and to come out with laws to curb environment pollution. But the legislation is scattered and can be found in various acts, guidelines, circulars, etc., which are posted on the website, but difficult to navigate and sometimes are ambiguous. There is a proposal for consolidation of various laws. The environmental laws are sometimes ambiguous. For example, at one point, there was an ambiguity regarding size of real estate projects that required prior environment clearance, due to which some companies defaulted. Then there are performance challenges. In some cases, laws framed are impossible of performance. For example, for the waste management, some of the associations, they went up in court and said that it's impossible of performance. And some of the difficulties were ironed out because of the case. Sometimes compliances are cumbersome regarding huge digital infrastructure and manpower costs, which medium scale and small scale companies may not be able to fulfill. There's legislative uncertainty. The enactment of piecemeal legislation creates uncertainty and could lead to companies unintentionally falling foul. And the various changes brought in by way of delegated legislation changes the goalposts frequently. There are cases where precedents are not followed, leading to unpredictability. And if we could have the next slide, please, and the last one. Then in environmental activism, there's a continuous cause of action that the courts have held. So companies can be held up for events occurred or actions taken decades back. And even though NGT provides for certain limitation, and the fact finding is left to committees constituting regulatory body officials or sometimes retired judges. And in some cases, even though report is favorable to the companies, it is continuously monitored by the courts. And Supreme Court has adversely noted over reliance on committee findings. And then there is the public interest litigation system, although it has brought about a lot of changes to the environmental landscape and has enforced environmental laws. But the wide leverage that is given that any person who has locus to initial litigation has led to motivated litigation as well. And mere averment is sufficient. And onus of proof, of course, is on the developer or industrialist to show that his or her action is environmentally benign. There's discretion on courts to impose environment compensation. So the formulas have not been streamlined, although there is move towards that. Then there is delay in disposal of cases. There's lack of finance and transitioning to greener solutions. And mitigation of climate change requires balancing of conflicting rights. For example, renewable energy projects are required, but the same also have an impact on biodiversity, which my co-panelists will really, focus more on. Thank you so much.
Thank you, Vanitha. That was really great. Thank you so much for that comprehensive overview. And I think I already have a lot of questions on that. And I probably should have said at the outset that there is a Q&A function. I see that that's being used already by one speaker viewer. So please feel free to ask your questions as we go along, and then we'll have time at the end to address them. I will hold off on asking my questions for now, but turn instead to Parul. And yes, thanks very much. Parul's going to provide a deep dive into the most recent and landmark climate case issued by the Supreme Court last year. Thank you, Parul.
Thanks, Rishi, and thanks for having me here, and thanks for everyone who's joined. So my research in my PhD focuses on the role of constitutions and human rights, as Rishi already mentioned, and I look at a comparative perspective between India and European jurisdictions with a focus on constitutions. So here I'm going to talk about the role of constitutional law specifically in India and provide some comparative insights as well. Next slide, please. So this is how I'm going to start about talking about this topic. So first, I think it's important to discuss what climate litigation is. Then I will move on to the role of constitutions before I get into environmental litigation in India, and specifically the judgment in MK Ranjitsinh, which was also mentioned by Vanitha. And in the end, I'll provide just a few comparative points between climate litigation, rights-based climate litigation in Europe and in India. Next slide, please. The one before this, please. Yeah, so this is a diagram from a book chapter by Pilen Osowski, which I really like because it talks about how climate litigation can mean many different things. So at the very core, climate litigation is litigation where climate change is raised as a central issue. These are called the core cases. If you see the next concentric circle, this is litigation where climate change is a peripheral issue. These are also known as periphery cases. But the circle can be much wider, as you can see, where litigation with climate change as only one motivation, but not raised as an issue, is also climate litigation, and where there's no specific climate change framing, that could also be climate litigation. And the reason why this is important is because in India, there's not been much litigation where climate change has been raised specifically as an issue. Next slide, please. And this is also because the core cases that we see, the darkest blue circle in the previous slide, it does reflect a narrow definition, but also a bias that we see in climate litigation databases, where there is more of a focus on global north cases where climate change has been raised specifically as an issue, whereas a broader definition would account for the more diverse global south experiences, because we have to understand that climate litigation, it's a field that's expanding rapidly and dynamically, but it is by no means a monolithic set of cases, right? So it's climate litigation or litigation in general in any jurisdiction is shaped by the socioeconomic circumstances of the country, the political context, and other factors. So we have to account for those when we start defining the term climate litigation. And what about cases that don't actually fit into these neat definitions that we see in the previous slide? We'll come to that as well. Now, in India, litigation has focused more on mainstream environmental issues rather than climate change specifically. This has been characterized as a stealthy or indirect approach that address the drivers of climate change rather than addressing climate change itself, which could be for strategic reasons where litigants want to rely on tried and tested arguments in the environmental jurisprudence realm. Next slide, please. So the reason why rights-based climate litigation worldwide is important is because we've seen what's known as a rights turn in climate litigation all over the world. This includes both global north and global south jurisdictions. But the difference is, I feel that in global south jurisdictions like India, this is actually a more natural route because there is an existing tradition of rights-based environmental litigation, which makes it a natural segue into climate change. Whereas it's a bit more new, I would say, in other jurisdictions. So, for example, we've seen cases where Articles 2 and 8 of the European Convention of Human Rights have been invoked, which pertain to the right to life, and similarly in national jurisdiction under national constitutions, for example, in Germany, also fundamental rights have been invoked for climate change purposes. Next slide, please. Why are constitutions important in the first place? So climate change is something that affects, it affects our existence, but also our quality of life, and therefore it encompasses a variety of social, economic, and cultural rights, which constitutions typically guarantee. But apart from these substantive provisions, constitutions are also important for providing access to justice through courts. And in countries like India, we've seen that environmental constitutionalism integrates both fundamental rights and environmental norms. Next slide, please. How the Indian Constitution does it specifically is through fundamental rights. So we have Article 21, which is the protection of life and personal liberty, and Article 14, which is equality before law. These are justiciable rights in the Indian constitutional framework. But apart from that, we also have non-justiciable provisions in the form of fundamental duties to protect and improve the natural environment, as well as directive principles of state policy, which are more in the nature of normative goals, policy goals for the state. Next slide, please. And as I mentioned, the relevance of the Constitution goes beyond just the substantive provisions, because it's also the procedural provisions, especially the way they've been interpreted by courts in the form of writ jurisdiction and public interest litigation, that are also important in the Indian Constitution. This is provided for under Article 32 and 226. And why are constitutions important? Why is the Constitution important in the Indian context when we have this massive regulatory framework for the environment, which Vanita just discussed in her presentation? It's because often these regulations are so complex or fragmented, inadequate in terms of enforcement capacity, and difficult to enforce also because of political will, that litigants have turned to courts, invoking the more established rights-based jurisprudence, and this has been a very, I would say, a very natural way to approach environmental issues in the Indian context, particularly as a form of gap filling in the statutory sort of framework, which Shivani, I think you've also discussed this in your book, where I would say it's two parallel sort of legal frameworks coming together. Next slide, please. So this is also something that Vanita briefly discussed in her presentation. We do have an established right to environment in the Indian context. This has been qualified in different ways, so right to a clean environment or a healthy or a hygienic environment. This has been derived from Article 21 of the Constitution primarily, but the other legal principles that have been cited in support of this have been the non-justiciable directive principles of state policy, the fundamental duties, as well as principles such as the polluter pays principle, precautionary principle, also the sustainable development principle. Next slide, please. So this right first emerged in the 1980s, where there are judgments that refer to the right to environment, although the legal basis is not fully clear in the beginning. Whereas in the 1990s, we see an emergence of a clearer nexus between the right to environment and Article 21, the right to life in the Constitution of India. In the 2000s, this application is more sure-footed, I would say, and I think it's my co-panelists can probably confirm that the right to environment is invoked almost as a matter of routine in Indian litigation cases, because it is by this point so well established and such a good complement to all the statutory arguments that you can take in court. And 2024, last year, is the first time we see the application of this right to a climate change context, and I'll get into that in a minute. But before that, what are the features of this right to environment? So first of all, it's very broad-based. It's been defined often in the context of pollution-free air and water. there is this constant conflict between the need to protect the environment and the need to further economic development. So there's this conflict between anthropocentricity and ecocentricity, which comes up particularly in the context of a developing economy. So sustainable development is often invoked, and then the case can go either way. Next slide, please. Now, what is this landmark ruling from last year? This is the MK Ranjitsinh case. So MK Ranjitsinh is a conservationist who filed, along with some other like-minded citizens, a petition to seek the protection of two endangered bird species, the Great Indian Bustard and Lesser Florican. There are very few of these birds that now survive. I believe the number is something like 150. And they are found, their natural habitat is the area in the west of India, so Gujarat and Rajasthan, which also happen to be renewable rich states in India. So one of the problems or one of the factors that has been endangering their lives is overhead power transmission lines, because these are large birds and they collide into these lines and die. So in 2021, to address this, the Supreme Court passed an order to restrict the installation of these overhead lines and directed the conversion of these power transmission lines to underground lines so that this problem would not arise. But this was not acceptable to the respondents, and in particular the ministries, who then went to the Supreme Court to seek a modification of this direction. Next slide, please. So the Supreme Court, what the Supreme Court does is actually quite interesting. So it discusses the problem, and then it discusses the context or the I would say the geographical area in which the problem arises, which, like I said, is in the states of Gujarat and Rajasthan, which contribute towards renewable energy production and therefore climate change mitigation in India. And the court comes to the conclusion, although it was not an argument, pleaded by either the petitioner or the respondent, that citizens in India have a right against the adverse effects of climate change, and this is a right that is derived from Article 21, which, like I said, has been the bedrock for right to environment cases, but also Article 14, where the court recognizes that climate change can affect different people differently because of differing vulnerabilities based on where you're located and socioeconomic factors. So Article 14 is a right to equality, and that can also be violated. And very significantly, the court notes that the right to environment and the right against adverse effects of climate change are two sides of the same coin. Ultimately, what the court does is it establishes a committee to look into this issue further, but I think it was quite clear from the judgment that there is an inclination to no longer continue with the previous order to convert the overhead lines into underground lines. The committee is still to submit their report. The case is still pending. Many extensions have been sought, but we won't get into that. I think the main question is what this judgment means for climate litigation in India. So it is a very significant judgment because, like I said, in contrast to previous cases where climate change has not come up as the direct framing, it does come up in this judgment. Although, of course, like I said, it's not pleaded by the parties, but it's something that the court proactively brings into the discussion itself. And so this is a boost for rights-based climate litigation in India, although how exactly it will be interpreted is more up to future cases and future judges. Unfortunately, it does come at the cost of biodiversity in India, so it is a rather blinkered view of what we need going forward, and it does give a bit of a clean chit to large renewable energy projects for this reason. And the second element that I want to point out is that it actually defies the conventional climate litigation nomenclature. So the categories that I outlined in my first slide, to my mind, it doesn't actually fit into any of these very neatly, because this is a case where climate change was not pleaded by the petitioners. It was brought in only incidentally by the respondents, but nowhere close to the degree to which the court amplified it by carving out this constitutional climate right. Next slide, please. I think one of the very important contributions of this judgment, regardless of how we want to evaluate it is that it sparked off a very vibrant discussion in India about climate change and the role of the judiciary. It's been rather polarizing because many people have applauded the pronouncement of this right and sort of the boost that it gives to climate justice, although others dispute that this is really a true it's really true climate justice that's being done. And the fact that I mentioned earlier that there is a bit of impunity being given to large renewable energy projects is also one of the critiques that's come up in the discussion. Next slide, please. And in many ways, it actually continues the trends that we've seen in the right to environment jurisprudence. So the first thing that I'd like to highlight is the utilization of familiar vocabulary in the form of pollution to address climate change, which, well, we can discuss whether that's also a bit limited because it doesn't actually go into other elements of emissions. And then there's a sustainable development tussle because solar energy is seen in conflict with conservation goals. Also the anthropocentricity, where the rights of humans trump the rights of these birds, if we could frame it like that. Next slide, please. And now, very quickly, I just want to provide a few points of contrast with rights-based climate litigation in Europe. So we have seen in the past few years a few cases where in various jurisdictions such as the Netherlands, in Germany, as well as recently in Switzerland, human rights or fundamental rights have been invoked to seek higher ambition in climate policy or climate law. And this has been characterized as framework litigation by some researchers at the Grantham Center. And the important element here is that there is reliance on human rights to seek greater ambition in emission reduction. Next, please. Greater ambition in overarching climate law and policy frameworks. Next slide, please. And this also brings me to how this is different from the Indian approach. Next, please. So this framework approach is based on looking at the overarching climate change framework, whereas in India, there's more of a micro approach where we look at environmental issues in a specific context, for example, a particular project or a cause. Next, please. As I mentioned, there's a reliance on climate law in European cases and a complete absence of climate law in an overarching climate law in the Indian context. So there's no reference to such a law. Next, please. And while there is an emission reduction framing based on greenhouse gas emission budgets in European jurisdictions, this is completely absent in the Indian context, where pollution as a more familiar term is the one that's invoked. Next, please. One more. Yeah, and the discussion in the European cases has been seen to focus predominantly on the future impact of climate change, whereas we can expect that the Indian cases might focus more on climate change in the here and now. So there's greater experiential proximity to climate change because of where India is located. Next, please. And the very last point that I'd like to make is that, as also Vanita mentioned, there are liberal rules on standing and locus standi in India, so it's quite easy to approach courts, even if you're not personally affected. But there are far more rigorous rules for that, especially as seen in the latest Ferran Klimas and Joren case in the ECHR. Next, please. Yeah, I wrote a bit more about this in a recent article. Next, please. Okay, I think I'm almost out of time, but I will just say at the end, could you click twice more, please? Thanks. I will just say that there's no right or wrong approach in climate litigation. I think both the global north and the global south can learn from each other and can interact with each other, which we are already seeing. I think in India, the focus on the rights-based jurisprudence has perhaps come at the cost of engaging more with a scientific approach, and perhaps this is something that could be remedied in future cases. Thanks. That's all.
Thank you, Parul. That's really interesting. I know we're kind of short on time, but that the particular challenge of kind of renewable energy versus also protecting endangered species, that's a problem that's cropped up in the UK as well. And there have been challenges in the context of wind turbines and birds, but obviously different legislative context, so it's been dealt with quite differently. And yeah, maybe we can turn to that again in the Q&A, but for now, I'll hand over to Shabani to provide her overview.
Thanks, Ruchi, and thanks so much for having me as part of the panel. It's not I'm towards the end, so I'm going to try and kind of wrap this up. I know we've taken up a lot of time, and
that's fine, Shabani. Take your full time. That's fine.
Okay. Yeah, thank you. Ruchi, if you could just go on to the next slide. So my co-panelists have already given kind of the lay of the land, the legal landscape in India, in particular about the relevant regulations, regulatory authority, case law, and how it's been developing and its relevance to climate litigation. I thought in part of my presentation could be that I wanted to kind of give a sense of where climate litigation is in India is even before the Ranjitsinh judgment that Parul spoke about, and kind of give an idea of where this could possibly go, because we've had the vocabulary of climate claims and climate justice, or the judiciary talking about climate issues even before Ranjitsinh came in 2024. So we do have, a decade of our judicial forums talking about it, and the way they talk about it very much fits in the second concentric circle, if not further away, that Parul mentioned earlier, which is basically cases in the periphery. It's only now that after the climate right has been recognized that we have people talking about a climate right. That's something new, of course. So I just wanted to give kind of a quick overview of the other kind of cases that one could consider as being peripheral climate cases in the Indian context. And as scholars such as Peel and Ossowski have written, Global South, perhaps that's really the trend that we are seeing. So this is kind of a categorization that I have come up with. And of course, I'm sure there are other ways of dicing and slicing the kind of cases that we've had. It's a pretty small set. It's a growing set of cases talking about climate change and different aspects of climate change, but not a very unmanageable set as yet. But I think most of us who work in this area in India expect this to grow, given the Ranjitsinh judgment in 2024. So the first category, and I'm talking about basically 4 categories. And the first category that I've thought of or kind of developed is that cases in which the parties or the courts refer to climate impacts of a government decision or the inability of the government to regulate certain activities. And in fact, there's a very recent order of the High Court in Rajasthan, which has taken suo moto cognizance of an issue. So it's on its own without any party coming to it, talked about how people in that state, and Rajasthan is the western part of India, that's where the desert is, it's extreme climate conditions, which are getting worse. And it's talked about how heat waves are going to become more frequent and how that's kind of one of the consequences of climate change. And it talks about how the government is not doing very much despite having a heat action plan in place. And it kind of forces the government's hand to actively take measures to protect the citizens. And it's using very much the climate language, which is very interesting. And remember, as I said, this is a suo moto case. So the judge has taken interest in this issue on his own. The second case, and I'm not going to go through all of them, but basically all of these judgments, the third one, which I've pointed out, which is a Rohtang Pass case of the National Green Tribunal. It's a decade-old judgment. But what's interesting, it's an issue on tourism. It's an issue on excessive tourism in the Himalayas and how it's impacting the biodiversity and the ecological sensitivity of that area. But the first part of the judgment talks about how climate change is leading to the impacts on snow melt. It talks about black carbon, it talks about glacier melting and all of that. And as Parul kind of also hinted to, there's a bit of a in the Ranjitsinh judgment, there's a bit of a disconnect between why the judgment goes into all of that and what the real issue was. But it's just to show an example of how the Indian judiciary is engaging with climate change at its own kind of understanding of it. The second set of cases that I look at is where the parties have approached for better implementation of a particular law. I mean, and as you know, we don't have a climate law, of a particular law or policy, and they use the climate language. On policy, we do have the National Action Plan on Climate Change, but so there have been few cases where parties have gone to court. Most of these are public interest litigation or cases before the National Green Tribunal, where the applicant or the petitioner has gone to court and said, look, there's a National Action Plan on Climate Change, or that we have a signatory at the Paris Agreement, and therefore we have NDCs that we should be meeting, and the government is not doing enough. In all three cases where this has come up, the court has not really issued any directions to the government, but has said, look, it sounds like the government is doing enough, or that it sounds like the government has its house in order and we don't need to worry about it. In some of the other cases, like the one I mentioned here, the Hanuman Lakshman Aroskar case, this issue was about whether a new airport should come up in the western state of Goa. And there were lots of issues. It was primarily an environmental impact assessment case where an approval granted to the airport was challenged. One of the grounds that and they had several issues on how the impact assessment had not been done correctly. The judgment in this matter, it's a 2019 case. Incidentally, the airport was allowed subsequently and it's fully functional by now. But one of the things that the judgment refers to is the SDGs, it talks about Paris Agreement, it talks about all these other commitments that India has internationally. So there is also this language of international environmental law and instruments that Indian judiciary often refers to, not necessarily deals with or kind of considers its application, but it engages with these documents. And I'm just using this as an example of, again, the language that the judiciary and the litigants are using. Go to the next slide. The third set of cases are where the parties request for directions for creation of new policies or realignment of existing processes in light of climate concerns. And this is actually an ongoing case, and that's why I've got Supreme Court 22025 with a question mark. Because first, the National Green Tribunal considered there's one particular case that I'm referring to, this Ridhima Pandey case, where a minor girl brought a matter to National Green Tribunal, and I think this kind of hit the headlines some time back, where she said the entire environmental impact assessment process, as well as the process of allowing for diversion of forest land, is devoid of climate considerations, and that the government should accommodate and modify these processes, regulatory processes, in a way that considers climate claims and climate issues. So this was something at the NGT. NGT incidentally gave an order which basically said that we believe that the government is doing very well and we don't see any need to issue any directions. The matter is now pending before the Supreme Court. The Supreme Court has appointed 2 lawyers as amicus to assist it. The Supreme Court in the recent direction has also asked many of the government departments to file their comments on certain issues in terms of their climate impacts. And the matter incidentally is scheduled to be heard day after tomorrow. So we're seeing how this goes. The second case that I highlight, and that's an interesting case, it's again a decade old, but I thought it was interesting because this is when the National Green Tribunal actually talks about how greenhouse gas emissions can potentially be regulated under existing Indian laws, which is the Environment Protection Act and the Air Act. So potentially we don't need a different law. They said that we, as the National Green Tribunal, can regulate it as a judicial forum because we have statutory powers, but they stopped short. They say that the greenhouse gas in question, which was the HFC 23, is something that the Indian government is looking at in the international forum, and there are various kind of negotiations still ongoing. So we are not going to issue directions, but we do understand that there are industrial processes in place right now in India, which are emitting significantly this particular GHGs and which need to be regulated. But again, we trust the Indian government to come up with a solution to this problem. The other 2 cases, incidentally, because you mentioned wind farms, Ruchi, there was a case in 2015 where the petitioner says that, look, wind farms in India are being given a lenient kind of approach, regulatory approach, because they're considered to be clean fuel, but they are leading to massive felling of forests. And there could be a climate impact in future that we must consider. And the final one is a category that I'm not going to go too much because, Parul's made an excellent presentation before me, where government is actually using climate concerns to defend its own actions. And not just the GIB case, the Ranjitsinh case, but previously also the government has tried to explain fees and cess that it's imposed on timber and things like that in kind of a vague, indirect sort of use climate to defend the fees and cess that are imposed, which was in some cases eventually struck down. So those are the kind of the last basket of cases. Just a few things that came out before I go to my final kind of concluding remarks, is that the rights-based language that Parul talks about, and which is where is relatively new. In fact, a similar presentation made a year ago, I would be saying that I'm very surprised that the Indian court is not using the rights-based language, because that's what we do very well. Environmental rights is something that, and socioeconomic rights, something that Indian Supreme Court and the high courts are very proud of, as we should be, but it hadn't actually surprisingly entered our language until the Ranjitsinh judgment. Interestingly, we have very few adaptation claims. I mean, I'm not even aware of any final judgment, which is surprising given how a vulnerable country we are. Most of the claims that I have gone through are all mitigation related, renewable energy, policy oriented. So I suspect and as Parul mentioned, and some of us have written on it, the Ranjitsinh judgment is kind of skewed, kind of giving much more weightage to the mitigation aspect of the climate problem than the adaptation. Because if you look kind of broadly, wildlife conservation, habitat conservation is a resilience adaptation issue, not so much a mitigation issue. And the Ranjitsinh judgment kind of relates climate to renewable energy, which is part of it, but not all of it. So in that sense, kind of the representation seems a bit skewed. I'm not taking away from the fact that it is definitely a watershed moment in Indian environmental jurisprudence. And finally, public trust doctrine, which globally has been used fairly widely in climate litigation and is very much part of Indian environmental law since 1996, is something which hasn't again found its way in climate concerns yet. So again, something perhaps I'm speaking too soon. A year from now, it might be in another judgment. Can we go to the next slide? So just a few remarks on where I think, given my experience, I think climate litigation is going to go in India. I think it's definitely going to grow post the 2024 judgment. Many of us who are in this area, even if we don't fully agree with some aspects of this thing, the fact that there's an articulation of a right, we're going to use it. And the way that litigation works in India, we use, particularly in environment, we use as much as we can, even if it's some of the framing is not entirely clear to us. As I also have said in my presentation, is climate claims have definitely entered the judicial vocabulary, which is great. One thing we can say with confidence that we don't have as yet on the bench in any of the judicial forums, climate deniers. We have mostly, I mean, I haven't come across any judge saying that, I'm not sure what you're talking about and I don't agree with you, but most of them, well, all of them have said that climate change is a reality. We of course have, and Vanika mentioned this, there's, we've had a history and a very rich history on public interest litigation, activism from the judiciary, fairly progressive. So all of that kind of makes for a very conducive environment for climate jurisprudence to grow, because that's really where many of the other jurisdictions are going. And as I said earlier, Indian courts' engagement with international law, and particularly international environmental law, has been quite deep in some ways, but there's a lot of engagement, let's say, but I'm not, sometimes not very deep, but it's, they're open to referring to international environmental law. Environmental rule of law is a new concept, relatively. There has been a series of 4 to 5 judgments of the Supreme Court of India, and it's very interesting because that's where the courts have said, look, the issue at hand is important, but what we really need is strong environmental processes, governance, institutions. And, all of that is important for climate law and legislation. And Ruchi, you mentioned climate law in the beginning, and that's not something we got into, and rightly so, because it's a discussion for litigation. But all of that's required for climate law to find a footing in India. Can we just go to the last slide? Where I'll end on a cynical note. It's just that I suspect it'll still be a little bit on the periphery. We have fair number of other imminent environmental crises. For instance, air quality, forest disappearing, losing species across the board. So maybe climate will be one of the arguments, but not the main issue, is my guess. And the judiciary, incidentally, has always had a very cautious engagement with economic development policy-related issues. And we know climate change is not just an environmental concern. It touches upon so many of economic and development issues. And our Indian judiciary has, in many instances, taken a step back and said, look, that's a policy concern, not something we can step into. On the other hand, we do have the co-benefits approach, which is very much part of India's NCAP, where local environmental problems, if they align with the climate issue, the judiciary might take that up. And finally, I think just transition, which is now definitely something spoken about at negotiations internationally, but very, very relevant to India, given its reliance on coal and the number of people employed in the coal industry and other industries which may have the impact. So just transition and how we are going to deal with those issues of livelihood concerns is something that are real and may be something that might slow down our progress towards more kind of progressive judgments. And I think that'd be a relevant consideration to slow down, just to say that. But I'll end here, Ruchi, and I hope I kept to time, and I'm happy to take on as we all answer questions. Thank you so much.
Thank you so much, Shivani. That was fascinating. I mean, really, from all three of you, I think that one of the key takeaways is that even though the legal, socioeconomic landscape, etc., is so different and the context is so different, I think the problems that we face and the issues that crop up are extremely similar, even if they're being tackled in the courts in a different way. And I think that was one of the points of drawing together the lessons from different jurisdictions that we're doing in these series, because actually pretty much everything, Shivani, that you mentioned in your last few slides are issues that we're grappling with. So, you know, adaptation cases, that's only becoming a thing here kind of in the last year or so, compared to the focus on mitigation, which is what we had seen previously. Similarly, you know, all the issues around just transition. I mean, the UK has also historically historically, it's benefited massively from the fossil fuel industry and other historic issues. But with kind of the move away from our fossil fuel industry as well, there are issues around just transition that are sometimes cited, and local environmental problems, including air quality, remain quite a concern even here in terms of particularly congested cities and so on. So that is, I think there are so many aspects that I could pick on, but I think I will at least start with some of the questions that our attendees have asked before I ask my own questions. So I think perhaps the first one that I wanted to pick up, because it's something that you touched on towards the end, Shivani, which is that do you think that India would benefit from a specialized climate change act in light of what you were talking about environmental rule of law? And I think this is also relevant to what Parul and Vanitha particularly talked about, which is the fragmented nature of environmental legislation, where climate comes in at a periphery as opposed to being the main focus. Shivani, perhaps you want to take that first?
Sure. So, yeah, I mean, whether we should have a climate law or not, yes, I think we need a climate law, but we need a climate law which is very much customized to India's needs. So it cannot be something that UK has or Kenya has or South Korea has, because we have very different constitutional setup. To begin with, we are a federal country, and many of the issues, particularly at the adaptation level, would be something that only our states have kind of legislative competence on. So it's very hard to say that Parliament could legislate comprehensively on climate change in India. So that's one point. The second thing, if I were to say what we need the climate change law on is, it would be something that sets in place this institutions and the procedures, not something that sets our emission targets, not something that locks in our industry into something. That's perhaps something, for instance, I believe UK has a law which has, you know, the carbon emissions kind of targets. Mm-hmm. And I don't think that works for a country like India, which is developing. Its carbon is just going to go up. There's no way of, you know, stopping it like that. And it's natural, but there have to be processes in place which make sure that the steep increase plateaus at some point, or at least reduces its rate. So I think in terms of setting in place processes, procedures, audit mechanisms, ensuring, so all of that, I think, requires an institutional mechanism which has a statutory backing and which ensures that there's fund flow, information flow, all of that across the states and the center, the federal system. So I think there are lots of hooks in the existing legal setup which need to be activated now, but we could also benefit hugely from a climate legislation.
Thank you. That's great. Vanitha, did you want to come in on that as well, or?
So I just came across, because of the question that there is a Council on Climate Change Bill 2021, which is in place to set up councils on climate change in each, in the center as well as the states, because of what Shivani mentioned, that it is very difficult to, sometimes implement. That this happened with the groundwater as well. But the Supreme Court, here also the courts had intervened, that every state said that we are a federal, we cannot, we cannot direct the states to, follow a standard groundwater regulation. And the Supreme Court had sort of come in and said that, no, you put the guidelines and states will have to follow, and they had made the states parties. So something like that. I mean, Supreme Court in its Article 142 of the Constitution has wide powers in India. So to that extent, yeah. So this bill is still pending. It's not yet become legislation.
Parul.
Yeah, if I could also just quickly come in. So I agree with Shivani that the context is different, and therefore, the peak will be different. But at the same time, I do think there's a need to legislatively anchor the 2070 climate neutrality target, because I just feel that without a legislation, there's very little accountability right now. Of course, the creation of such a legislation will be a complex process. But what we have right now are the national and state action plans on climate change, which are not binding and are frankly quite dated. And in fact, I along with a co-author, Abhay Rajnaik, wrote on this back in 2018 that we need a law. And yeah, it's been like 7 years since then, and nothing has come into place. So I do think we need some kind of law just for creating greater accountability and thinking towards the end goal.
Thank you. Yeah, thanks both of you there. So I think maybe if I could, one of the questions has something that draws on, Parul, what you were just mentioning about the targets that have been set under the NDC and so on. And of course, there's the 2070, which is the sort of long-term goal. To the extent that these are commitments under the Paris Agreement, to what extent do you see the courts sort of deferring to national government on progress? Because that's something that, an issue that we grapple with in our courts as well, where, well, we have the Climate Change Act, so it's a bit different because we have kind of the stepping stones to plead arguments in relation to. But yeah, what kind of landscape do you see in terms of judicial deference?
Well, I can start. I think, yeah, it's not easy to answer, especially because of this sustainable development conundrum that we find ourselves in. And Shivani mentioned that courts are often cautious about overstepping in the policy realm, but equally there are enough instances of they having done it. So as I also said in my presentation, it can kind of go either way depending on the facts of the case. I do think that the Ranjitsinh judgment provides a new framing, and I'm curious to see how it will play out. I think it might be more of the same, but sort of old wine in a new bottle, a new framing. And actually, one example that I really like was something that you wrote, Shivani, in an article of yours reacting to the judgment, where you talk about this need to balance sustainable development and the adverse effects of climate change. So the court has only said that citizens of India have a right against the adverse effects of climate change, but what this actually means in practice could be could have very divergent sort of outcomes. So I think the example, Shivani, you had was about the use of coal. And so on the one hand, it could be argued that we need to restrict coal to reduce emissions and meet India's international targets. But on the other hand, it could equally be argued that we need to help citizens adapt to the effects of climate change, including very hot summers. And so you might need more coal just to support, air conditioning and electricity and fans and so on. So I think there's a lot of room for interpretation, creative interpretation, and it remains to be seen. I think it's, well, to also present a very cynical view. Some also think that because the Ranjitsinh judgment didn't actually address what it was supposed to by pronouncing a climate right, this is actually obiter dicta and perhaps is not binding. So I think it's still quite wide open to what extent courts will adopt this constitutional right and apply it.
Okay, brilliant. Thank you. I am going to ask my own question now before I turn to some of the others. So one of the things that I read in the Ranjitsinh judgment was, and I think Parul, you mentioned it, was the fact that the court talked about the differential impacts of climate change on certain populations, so women and vulnerable populations, etc. And I thought that that was really interesting, and we are seeing that kind of analysis in other court decisions around the world. But I wanted to understand how the court gets there. So not just the Supreme Court, but how the Indian courts are generally, or to what extent they are receptive of evidence, and what kind of scientific evidence they, petitioners need to provide. Just by way of example, I mean, in this country, I think the courts sort of do accept, the IPCC reports, things like that, but we haven't always seen them to be engaging massively on the scientific side of things. So if you could provide an overview of what tends to go down in the Indian judiciary, that would be really helpful. Any one of you.
So like I mentioned, if I may, I'll just pitch in on that. As I said, that there has been an over-reliance on commissions. The NGT has the power to set up commissions and a committee, and which also consists sometimes of scientific advisory. I mean, they ask the CPCB to sort of set up a special committee which will consist of scientific advisory. They also, so therefore, on fact-finding, the Supreme Court has also set up some sort of, central CEC, some specialized committees, and they rely on what the committees, on the fact finding of the committees. But the Supreme Court in some of the judgments has said you can't just blindly rely on the committees. You have to apply your mind to it. Yeah. And for example, there was a judgment Sterlite. I mean, the tribal lands had been taken up, and there was some non-disclosure in the environment impact assessment report. The Supreme Court came down heavily and sort of shut down, relying upon the committee report to that extent.
And Ruchi, increasingly we are seeing people relying on, for instance, IPCC summary of policymakers. I mean, all of this is also getting filed in court. They're also filing peer-reviewed journal articles, but it's not a standardized evidence base, if I may call that. So it's fairly flexible depending on which judicial forum you have approached. Also fairly flexible depending on who is the bench, who is arguing. So the way, I mean, I often wonder whether we are well placed to comment on the trend in climate litigation in India, because the polyvocal court, it's very hard as lawyers and legal academics who are commenting to actually discern a trend with any degree of predictability. So yeah.
And to some extent, if I may pitch in that, because of the PIL system, and especially in NGT also now letter petitions, you may simply just file a letter and raise an environment issue. So the locus of proving, the onus of proving whether or not this is environment friendly or not, in the absence of any facts, is left to either the committee or to the polluters who have vested interest, right? So there's a lack of bringing forward proper proof is left to other parties rather than the person who has brought forth the case. I mean, of course, the Supreme Court appoints amicus curiae, and they have done a fabulous job. So it's to that extent.
Brilliant. Thank you so much. Okay, I'm just mindful of time, and there are so many questions. So what I will suggest, I mean, people have our email addresses on the slide. If there are particular issues that you want to follow up with, I think all the speakers and myself are open to receiving follow-up questions or discussions. I will just take one final question, which is very hard to choose, but my eyes have just rested on the words adaptation and also the right to life with dignity. And perhaps that's the lens with which adaptation cases should be viewed. I was just wondering if anyone else has any final comments on how we look to the future and building more resilient communities.
So I mean, I think as I said during my presentation, adaptation and resilience has to be very much the center of any climate policy that India comes up with and climate law. Center, but not the only thing. I just don't know what should be the role of the courts in that. Perhaps the role of the court can be ensuring no backsliding, ensuring that, because a lot of the adaptation and resilience is at the end of the day policy making, is at the end of the implementation. It requires institutional heft. It requires, schemes and fund flows across the government to work, because, you have low-lying areas which need to be protected. You have people needing ORS solutions, or some, you need protection from dehydration during heat waves. I mean, that's the kind of thing. So you can't have the judiciary stepping into this daily governance. You may need it when there's complete negligence, which in India is known to happen. But I personally don't feel the judiciary can be in the forefront of that. It has to be around, but it has to be something the government and perhaps the climate legislation can kind of push forward that agenda.
Okay, thank you so much for that, Shivani, and all the speakers. I think with the eye on the time, we will draw the discussion to a close there. But thanks once again for giving up your time to all the panelists. That was so interesting. Just to flag that this will be online, so people can watch it at leisure and share it also amongst your networks. And then the next session for Cornerstone Climate is going to be focused on Ireland, which is in May. So look out for in your emails for publicity about that event. So yes, thank you very much. And I hope you have a good rest of the day.
Thanks a lot.
Thank you.
Thank you. Bye.